Hello, hello. Happy belated Constitution Day, everybody. So it is my honor to welcome you all here tonight to this Constitution Day event for what I think is, for many of us, a once-in-a-lifetime kind of event. I just hope you're all as excited as I am to have a sitting Supreme Court justice here at our school. If that's even possible. But to really get things going, I'd like to introduce to you the president of Rhodes College. She's only in her third year here, but I think she has demonstrated a love for this place, a love for this community, and she's shown us that she's the best at what she does. So please join me in welcoming President Marjorie Haas.
Good evening. What a pleasure to have you all here. I am delighted to welcome you here on behalf of Rhodes College. And seeing this room full of people from all corners of our campus, as well as all corners of Memphis, reminds me of the crucial civic responsibility we have as an institution of higher learning. Our duty to model the disinterested search for truth and the pursuit of wisdom has perhaps never been more important. Tonight, we gather not just in honor of a man, but in honor of an institution, in honor of the constitutional democracy that protects and preserves our individual liberties and enshrines justice as a communal value and aspiration. Our distinguished guest will be introduced by Dr. Tim Huebner, the Irma O. Steinberg Professor of History at Rhodes College and Associate Provost. Dr. Huebner joined the Rhodes faculty in 1995 and has been widely recognized for the excellence of his teaching and his scholarship. Among many other accolades, Dr. Huebner was named the 2004 Tennessee Professor of the Year. In 2015, Tim led the college's efforts to bring the late Justice Scalia to Rhodes. And we are incredibly honored to have had two of our nation's leading jurists grace our campus in recent years. Dr. Huebner is himself a noted constitutional scholar, and we're grateful for his leadership in arranging tonight's program. Please join me in welcoming Dr. Tim Huebner.
Good evening. Thank you, President Haas. It is my great pleasure to welcome you to our campus for our annual Constitution Day lecture. Some will note that we are marking Constitution Day a bit late this year, as has already been said. It was actually September 17th that the Constitution was signed, but any commemoration, even a late one, should be cause for both celebration and reflection. So first, a few words of celebration. Make no mistake, the Constitution of the United States is worth celebrating. Its structure divides and separates power, ensuring that no one branch or no one person can abuse that power. It puts the national government and the states in constant dialogue with each other, allowing states to serve, as Justice Louis Brandeis put it, as laboratories of democracy, while ensuring that individual rights are protected by the nation's highest court. It features a Bill of Rights, where these rights are explicitly stated, leaving no doubt as to whether or not our society values such cherished liberties as religious freedom, freedom of speech, or freedom of the press. We should celebrate the Constitution finally, because it is one of only a handful of texts that all Americans hold in common. No matter where your family came from, no matter where you live, no matter which political party you identify with, we are all included in the we the people language that begins this enduring 232-year-old document. But commemorations are also occasions for reflection. One of the fundamental ways to reflect on the Constitution is to be aware of what it says. And that involves actually reading it, which I invite you to do. Please, if you have not already done so, pick up a complimentary copy before you leave tonight. Special thanks to Professor Dan Cullen for providing these. Also helping us to reflect on the meaning of the Constitution, particularly its amendments, are the students in Professor Carl Erickson's digital art class. Professor Erickson's students produced a series of posters that you may have noticed when you walked in. They present the words of the amendments in arresting and compelling ways. So if you didn't notice, please take a look on your way out. Our speaker tonight, of course, will especially help us to reflect on the Constitution and on the Supreme Court that it established. But before I introduce him, I want to extend special thanks to all of those who have helped make this event possible. Our sponsors include the Office of Academic Affairs, the Department of Political Science, the Department of History, the Jack Miller Center for the Teaching of America's Founding Principles and History, and the Lynn and Henry Turley Memphis Center. Our team of organizers includes Jenna Wade, Nikki Moore, Kim Bennett, and Kristen Hunt from the Development Office, Matt Guerin and Charlie Kenny from the Communications Office, and Ike Slose from Campus Safety. Thanks to all of them and their staffs for working so hard on this. I also want to acknowledge our generous partners at St. Jude Children's Research Hospital, who today hosted Dr. Joanna Breyer, a retired clinical psychologist. Dr. Breyer is the author of When Your Child is Sick, a guide to navigating the practical and emotional challenges of caring for a child who is very ill. We thank Dr. Sean Phipps, chair of the psychology department at St. Jude, along with our own faculty liaison to St. Jude, Professor Gary Lindquester, for helping to organize her visit. And we are honored to have Dr. Breyer here with us tonight. Before I introduce Dr. Breyer's husband, I do want to lay out what will happen next. When Justice Breyer comes on stage, you will be able to take pictures for the first 2 minutes of his presentation, but after that, there should be no photography. Justice Breyer will speak for about 25 or 30 minutes, and after the lecture, Justice Breyer and I will sit down together, and I will ask some questions which we have solicited in advance from some of our students, faculty, and staff. And now, to help us reflect on the Constitution and the Supreme Court and what they mean in modern America and in the modern world, it is my pleasure to introduce to you our guest. A native of San Francisco, Stephen Breyer graduated from Stanford, went to Oxford as a Marshall Scholar, and graduated from Harvard Law School in 1964. He taught law for many years as a professor at Harvard Law School and at the Kennedy School of Government. He also worked as a Supreme Court law clerk for Justice Arthur Goldberg, as a Justice Department lawyer in the area of antitrust. He was an assistant Watergate special prosecutor and chief counsel of the Senate Judiciary Committee. In 1980, he was appointed to the U.S. Court of Appeals for the First Circuit by President Carter, and he became chief judge in 1990. In 1994, he was appointed Associate Justice of the U.S. Supreme Court by President Bill Clinton. Justice Breyer has written books and articles about administrative law, economic regulation, and making democracy work, A Judge's View, a book about the U.S. Constitution. He's also the author of Active Liberty, Interpreting Our Democratic Constitution. His most recent book is The Court and the World, American Law and the New Global Realities, published in 2016. And that book will be the subject of his talk here tonight. He and his wife have 3 children and 5 grandchildren. Justice Breyer, it is worth noting, graciously agreed to speak to us tonight despite a busy schedule. Last night he was in North Carolina, and tomorrow morning he and his wife will head back to Washington so he can take his seat on the bench on Monday morning, the first Monday in October. We're honored to have him here with us this evening. Please join me in welcoming Justice Stephen Breyer.
Thank you very much. Well, thank you very much. It was lovely introductions, and thank you, President Haas, and thank you for being here. Our congressman is here. We have federal judges and state judges and the faculty, and my goodness, and all of these students. You realize, don't tell anyone, Memphis Madness is about to be going on. Don't all leave at once. There we are. And I haven't been to Memphis before. I have liked it. I love looking at the river. I love my bowl of gumbo. I love this. This campus is beautiful, and the students were great whom I've spoken to. I mean, my goodness, thank you very much. You know, he even mentioned my regulation book. My God. Do you know what? The Los Angeles Times, somehow a reviewer got a hold of that book. I don't know why. It's pretty technical. And here's what he wrote. He said, in Alice in Wonderland, Alice emerges from the pool of tears with the Dormouse. And the Dormouse begins to read Hume's History of England out loud. Why are you reading that? Says Alice. Because, says the Dormouse, we're wet. And this is the driest thing I know. So this was before Breyer wrote this book. He said, well, I've tried to be more interesting here. I will talk about one aspect of a changing court, and the aspect of the changing court in respect to a changing world, which is the international part. And the way I started, I sort of felt like many of us feel. I mean, you hear these words every day: globalization, interdependence, multinational. Well, this is the liberal arts college. You'll understand it. I mean, I feel like in the Charterhouse of Parma, you know, the hero is Fabrice Del Dongo, and he is out there at Waterloo. And he's a young boy, really, and he's fighting, and there's smoke all over the battlefield, and the bullets are flying around, and Napoleon is going back and forth on his horse, and Fabrice is thinking to himself, you know, something really important is going on here. I wish I knew what it was. And that was sort of my view when I heard these words, and gradually as I looked into it more and thought about it more, I think, well, we're tempted to think something I think is wrong. We're tempted to think, well, there's globalization over here, and then there's community and localism and tribalism, whatever, and these are two forces in conflict. Well, maybe for some people that is how they see it. That is not how I see it at the court. I want to show you something. And what I want to show you with a few examples is that this world today, I think, is a world characterized by both, that are not at war with each other. But we, particularly professionals, have to be able to deal with a world where both are important. Now, when I came to the court 24, 25 years, oh gosh, a long time ago, when I came to the court, I mean, I said some things about international law, and I got a professor who got up and said, name one that's important to you. You know, I had a hard time. But because very few cases involved anything international, anything beyond our shores, some, but not many. I have no problem today. It's really risen to 20, 30%, sometimes more, where you have to know what's going on beyond our shores in order to solve problems, statutes, constitutional interpretations, local. We are a local court. You might all think, oh, well, yeah, we are, though. We interpret statutes, we interpret constitution, we interpret federal law, which, by the way, I don't know if the congressman will tell you this, but federal law is only a tiny part of law in America. Almost all law is state law. Family law, criminal law mostly, business law, you name it, it's state. We're only dealing with federal in our court. And so we're limited. But what I want to show you is not that. What I want to show you is what has happened in the court in respect to matters beyond our shores suddenly coming right in to these local decision makings and requiring them to think about it. I'll give you 2 or 3. I have more in my book. I've tried to be less dry than the book about, but in any case, that's another subject. But there we are, okay? So let me pick 2 or 3, and I'll show you what's happened. One, which is glamorous and interesting and important, and not always so much, involves national security. I mean, go back, wartime, conflict. The basic rule from the Romans on was best said by Cicero. He said something like enim arma legis silente or something. I translated that to an audience and said, well, that means when the cannons roar, the law falls silent. And so somebody immediately pointed out that the Romans didn't have cannons. Now, it sort of wrecked my example, but nonetheless, you see the point. You see the point. And that was in America, really the law for a very long time. Go back to Adams and the Alien and the Sedition Acts. Courts didn't get involved. Try the Civil War. I mean, we understand it was tough for President Lincoln. My goodness, that was tough. But still, he did not necessarily get he would put people in jail at the drop of a hat. Not personally, but the generals or his Secretary of State called in the British ambassador one day and said, you see that button? I can push that button and I can have anybody I want in New York thrown into prison. You see that one? I can push that one and have anyone I want in Indiana thrown into prison. Tell me, he said, does the Queen of England have such power? Mm-hmm. Oh, of course, the court did get involved eventually in a couple of cases after the war was over. After it was over. Quite a different matter. But that was pretty much the attitude. I mean, go look sometimes through the history of the First World War, where President Wilson suppressed speech, I would say, right, left, and center. I don't want to overstate it, but that seems fair. Court didn't do much. A few dissents. Or let's jump to World War II, where 70,000 American citizens of Japanese origin were removed from the West Coast and put into camps, prison camps, in the Intermountain region. Mm-hmm. And you know who was for it? Earl Warren. He said it was the worst thing I ever did. You know who was against it? J. Edgar Hoover. That name means something to some of us. He said, don't do it. He says, the FBI can handle this. Well, it got to the Supreme Court. Korematsu. I met him once, Korematsu. He was, it's interesting. He was an older man at that point, feisty guy. and he was our next-door neighbor in Cambridge. Her father had been the head of the ACLU in San Francisco, used to play poker with my father. The ACLU, by the way, wouldn't support him when he started off representing Korematsu. But they did by the time he got to the Supreme Court. It got to the Supreme Court where there was Black, Douglas, Frankfurter, the great liberals, and Korematsu thought, well, you can't do something like this in America. And that Supreme Court, 6-3, voted to uphold it. And that was 1944. Nobody thought the Japanese were going to invade San Francisco in 1944. And according to Frankfurter, the first thing that Black said, who was running the conference that morning, he said, well, he said to the others, somebody has to run this war, Roosevelt or us, and we can't. Well, was that Black or was that Cicero? I mean, there we are. And yeah, 3 dissented. The dissents, I think, were right. People read them now. Murphy, Roberts, Jackson. But that was what happened. Then the tide began to change. It began to change probably with the steel seizure case, where President Truman was told by the court, Black, that he could not, during the Korean War, seize the steel mills. I won't go into the details there, but I've always thought in reading that case that really the court is saying to Roosevelt, you went too far. Now, of course, it's easier to say that after Roosevelt has died and there is a much less popular president. But then, subsequent to that, since I've been there actually, we had 4 cases out of Guantanamo. 4. They were not the most popular plaintiffs. I mean, one was bin Laden's driver. They were all suing the President of the United States, or the Secretary of Defense, and they all won. And when Congress passed a law that said that they didn't have a right to go to court, our court held that it was unconstitutional. That was a change. And I think Sandra O'Connor picked up the attitude pretty well of what the court was doing in Korematsu. She said the Constitution does not write a blank check to the president, not even in time of war. Well, the question goes into your mind, fine. It does not write a blank check. What kind of check does it write? You see why no one likes our 4 opinions. One group of people say, hey, you shouldn't have gotten into this. The president should be able to do what he wants. And another group of people say, why didn't you tell us more specifically what the president can do and what the president cannot do, and what about hearsay and all this other stuff? And the answer to that question is very simple. The reason we didn't say all the things the president can do and what he cannot do is because we don't know. That's why. And so these opinions, Cicero's gone, but these opinions and the blank check provide just as much a question as an answer. And where do we go to try to find out the answers to the questions that are related and come up to us now and will come up to us in the future, or might well? And I say, well, you're not going to just have to be able to restrict yourself to what happens in America. Terrorism is a worldwide problem. Other countries that are democracies have dealt with this too. It may be helpful, or it may not, but it may be helpful to know what Britain has done, to know, as we learned in an exchange, that they have, for the real dangerous aliens who are there and they feel are terrorists and they don't want to tell them anything, they have 2 lawyers, one lawyer with the classified information and one representing the defendant, and they can talk to each other and get the gist of what that classified information says without the detail. Well, that's a little complicated. I don't know if that's the best system or not. Or Israel. They lock up a terrorist on the West Bank. Accused terrorist. The army says he's a terrorist. He says he's not. And how do we do? Well, do we just give him a lawyer? No, says Israel. You see, what he'll do is he'll tell the lawyer to say, go home and tell your mother I'm fine. Go tell my mother I'm fine. And what that will mean is blow up the cafe. And that's not a made-up problem. It's a real problem. So they've developed a system where, all right, the Army has to make out a case before a judge, ex parte, in camera, where you cannot. Why he can't have a lawyer. And if the judge says, okay, I see it, it only lasts for like a few days, and then they have to come back and explain why it must last longer. And each time it gets harder for them to justify what they're doing. Well, that doesn't sound so good. I don't know. But all I'm trying to do here is point out that if we're really going to decide a lot in this area, we have to remember what Justice Black said. And we can't do it out of ignorance. And out of ignorance, we'll get things wrong. And it's not a laughing matter in this area. And so I suspect we'll have to look, among other places, to what goes on abroad in respect to terrorism, in respect to what other democracies do, and then have informed decisions, or at least more informed than they would be if we didn't look. Well, let's jump to a different area, totally. Let's try commerce. I mean, we had a case where the plaintiff is in Ecuador, he is a vitamin distributor. That vitamin distributor is suing a vitamin manufacturer in Holland under the antitrust laws for being part of a cartel that's raising the price of vitamins, and there was an American member too, and they're suing in New York. Hey, why is he suing in New York instead of Holland? Well, one possible reason is that the price of vitamins was so high he got too weak and he couldn't get to Holland. That's possible. Treble damages may have something to do with it as well. But we have to decide, you say, how does this, oh, by the way, read the statute. Read it. And you get an answer out of that statute. I'm not saying, Congressman, all the statutes are obscure, but I'm saying some are. And this was. And we had briefs from the European Union cartel authorities. We had briefs from Canada, from Japan, from all over the world. Yeah, because it matters to them and their own enforcement. And we eventually decided the case. My point is that this is a matter that involves the EU, that involves Canada, that involves others, and we have to know what they're doing to it. Or try a securities case. We had a case where I think it was an Australian plaintiff and is suing an Australian company saying he paid too much for his shares sold on the Australian exchange because that company bought some land in Florida fraudulently. Does that violate our anti-fraud laws? I think we would have said yes 20, 30 years ago. But we got briefs from the Australian anti-fraud people, from the European fraud people, from fraud people all over the world. I mean, enforcers, not frauds, but and they said, stay out of this. They're doing their job there, and you get involved here, and you'll just have more problems. And that's what we did. I joined the opinion. Nino wrote the opinion. And I think that he said in that opinion that what they told us, the anti-fraud enforcers in Australia, mattered. Of course it matters, because these are practical questions in part. And how did you get that law enforced? Or we had a great case in copyright. I love this one. We have a student up in Cornell, and he's from Thailand, and he discovers his books, his texts, he was a scientist, in English, in Thailand, published, are half the price. So he writes to his parents and says, send me a few. Well, they sent more than a few. And he was hand over fist, you know. and the publishers got a little annoyed, and they brought a lawsuit. And could he have the right to do it or not? Again, read the statute. Oh. We had briefs from all over the world. A stack like that. And I wondered, on this case is a very technical case. I mean, really, why are they? Why this stack of briefs from everybody? And the answer I found about 2/3 of the way through in a brief that said, you know, your answer in this case is going to affect $2 trillion worth of commerce. Yeah. I mean, even today, $1 trillion is a lot of money. You see? Or try civil rights. Dali Filartiga, Paraguay, citizen of Paraguay. Brother, citizen of Paraguay. Where are they? Paraguay. Who runs it? A dictator. And what does the dictator do? He gets one of his men to kill the brother. She comes up to New York, and she finds the killer. And she finds a statute, or her lawyer did, which said the federal courts have jurisdiction. They have jurisdiction to give tort recovery, monetary damages, to a person injured by a violation of the law of nations. That's a statute. When was it passed? 1790s. 1790s? Why? Well, they were against pirates. See, the rule of law at that time was you find a pirate anywhere, you can hang him. And by the way, hang him upside down first, shake out the money, and give it to his victims. All right. So that was the idea. And now, who are today's pirates? Who are they? The court said, this is one of them. And she went back saying, I came to the United States hoping for maybe a confrontation or justice, and I got a lot more. Yeah, not bad. Good idea. Let's try suing South African, not a South African, American firms that did business in South Africa under apartheid. Can you do it? Maybe. You know who didn't want us to do it? The modern South African government. They filed briefs in the New York court and said, judges, stay out of this. We have our way of resolving these apartheid problems, and it's called the Truth and Reconciliation Commission. And one thing we do not want is a group of American judges in New York suddenly interfering with our process. And what weight should we give that? And how should we decide? And what should the rules be? And after all, if we can bring a case involving something that happened in Paraguay in some other country, Paraguay can bring a case saying about what happens here, and Belgium does bring cases like that, and Spain has done that too, and which ones, and how do you work it out? And maybe what you should do is Immanuel Kant, you're a philosopher, Immanuel Kant, your rule of decision, judge, or me, judge, should be something that's generalizable and that will work if followed by all countries. Easier said than done, but there is no Supreme Court of the world to work out conflicts. And you want to totally give up this civil rights statute? I don't. And is there a clear answer how to do it? No. And do you have to take foreign interests into account? Of course. And you have to know something about it? Certainly. A big issue in the American courts. And of course we decide treaties, we always have, but the nature of treaties has changed. It isn't just between two people. We had 3 cases in a period of 2 years, I think, involving the Hague Convention on Abduction of Children. Hard to figure out. The child's here with the mother, saying abuse by the father. And does he send him back immediately or not, or what do you do? And you know who the group of judges in the United States who know the least about family matters? I'm one of them. And my 8 colleagues are right there with me. And so why are we deciding this? I mean, in state courts, they have specialized family judges, which is really a tough job. And they're the ones who know something about it. And federal judges, no, they have very little experience. Why is it in our court? Because it's in a treaty. That's why. And why is it in a treaty? Because more and more marriage is a matter where you can find husband and wife, partners of different places, different countries. And that isn't something that just Happened overnight, gradually, and it's not going to go away. It's going to go up, not down. And so we try to resolve these things by treaties. And then the judges are called upon to answer questions under the treaty. And now you better watch it pretty closely if you're in that field, because the judges are likely to make mistakes. You may have to revise the treaty. But nonetheless, all I am trying to point out is this is increasing, increasing, increasing. I have a friend, Professor Cassesi in Italy, and he sent some research students together, and they were supposed to look up how many organizations are there that actually have the power to make a law or a rule that in practice affects citizens, businesses, or people of more than one nation. Okay? How many do you think? How many think more than 100? 200? I mean, how many organizations, UN, WTO, how many do you think there are can affect? Do you think more than 50? More than 100? Raise your hand if you think more than 100. More than 500? More than 1,000? More than 2,000? Well, there are more than 2,000. And we belong to 800 of them. Yeah. And some of them, the UN, that, or the World Trade Organization, or the International Monetary Fund. Have you ever heard of the Southern Blue Whale Commission? Ah. What about the International Olive Oil Council? Uh-huh. They are all over the place. And they affect what Congress legislates. Of course. The Ball Convention, where the SEC goes and meets with bankers and comes back and then takes the rules they've all decided, has notice and comment, and it drops them anyway. All right, you see, they're all over the place. And we're not going to withdraw from those 800, and I don't think we should. And they work in different ways. All right, I'm giving you a picture, and my point is it is there. And are we going to change it? I doubt it. I doubt it. I mean, they do different things. Some of them set standards, some of them make rules, some of them suggest that Congress passes laws, which it does, and then maybe it affects the interpretation. The D.C. Circuit's had several of those, and it's all over the place. Conclusion. You see? It's a conclusion. You think I'm going to say something that'll be really helpful about this, but I'm not. What I want to do is point out what this problem is. And it's there. And you think it won't lead to cases? Of course it will, all over the place. And when I say they require us, we're not going to quit the International Civil Aviation Authority. And by the way, can they legally enforce their rules? I don't know, but they can ground the airplanes. And nobody's going to fly when that airplane is grounded, and we're not going to quit the organization because, all right, you see the point? And that may be even true of olive oil. I don't know. But there are many, many ways of going about this. This being how we are going to approach problems that are there in this world. Problems. It takes about 2 minutes to start thinking of environmental problems, of health problems, of safety problems, of problems of terrorism, of problems of immigration. People walk, and they're everywhere. It's not just here. And what conclusions I draw from that, well, I'll let you read about it, and then you can draw your own conclusions. But I draw a few. One of them is the more you read about this, the more you think it isn't good versus evil. It isn't somehow globalization over here or localism or tribalism there. It's that we are in a world where there is both. And we're not the only ones. The architects are like this. For my whatever set of reasons, I got on a committee involving architecture, and they give out a prize. And the great architects at the moment are trying not just to use an international style, but they'll use metal and things, but they'll do it in such a way that they call attention also to the locality where they are, and to its history, and to its environment. See, both. It's local and it's international. And that is fact. It helps to look at it as fact. That was really pointed out to me. But I was on a panel with a member of Congress who, very good, I liked him very much, but he went on and on at some length about how we shouldn't look to foreign courts or foreign decisions or whatever it is. So I said, that seems to be aimed at me. And he said, yes, it was aimed at you. So I said, fine. Now, let me tell you why. These are people all over the world, and there are democracies across the world now, and many have courts, and those courts do have the last word of interpretation, and they have problems like ours. They have documents like ours. Why don't I read what they say? I don't have to follow it, but read it. I'll learn something. Oh, that was a pretty good point, don't you think? Yeah, he said read it. It's fine with me. He said just don't refer to it in your opinion. Then, not knowing enough to keep quiet, I then said, but look, it's more than that. It's that there are a lot of countries that have just become democracies. They've set up these judiciaries. They're not, and if the Supreme Court of the United States, which is an institution that they've heard of, refers to their opinion, that might help them maybe go to their legislature and say, don't do some of the things you're planning on doing. We're a serious court, and da-da-da. All right, you know what he said? He said, fine. He said, write them a letter. So I realized that he's reflecting, actually, and many do, a very important strain of American law, a very important thought that Madison had. Madison said that he said, this document, the Constitution, he said, it is a document where liberty delegates power. It is not a document of power delegating liberty. What he meant by that is that, unlike many European countries at the time, power in the United States rests in the people. That's where the liberty is. It's in the people, and they can delegate to the federal government power. But what they don't delegate remains with them. That's very different from Louis XIV or Louis XVI or whatever Louis you want. Because what those Louis did is they had the power, and maybe they delegate liberty, but the power is at the center. And you can see that very much if you think about our judiciary. Because in many states they're elected, which has its pros and cons, which I won't go into. But even federal judges, they're appointed by politically responsive people. And so the average citizen can think, once we're appointed, can't control us anymore, but we do have confirmation, that's another subject too. But you see, the average American can think, I have some control over even who these judges are. I don't have any control at all over the judges outside the country, who they are. You see, all that, I think, is underlying what the congressman's reaction was. So what? What's my way of dealing with that? It's not to make a better argument. I've learned that over time. That sometimes, although we deal in arguments, it's not the argument. Give the example. Do what the lawyers call confession and avoidance. Give them the example. And that's why this book is filled with examples. That's why I've given you a few. Because I'm really speaking to him. And what I want to say to him, look, this is the world. This is where we are. What do you suggest we do? I mean, what's your point? I mean, other countries are going to get together and deal with environmental matters. Other countries are going to try to deal with matters of health, with commerce, and hey, we can participate or not. And if we don't participate, well, they'll do their own thing. They will go their own way. We will have to live with what they come up with, and we will not have had a say in it. Don't you think it might be better to participate? Now, here I'm getting beyond law, but I'm showing you how the lawyers and the judges have to participate. And is that such a bad thing? No. Of course, I don't think it is. And I think it calms down once you see these as facts. It sort of calms down the level of emotion. You don't have big war between forces. We have a world where both is true. And there are many, many ways to skin this cat. I mean, there are all kinds of ways of people cooperating. You don't have to be the EU. We're not part of the EU. I mean, you don't have to have a treaty. You don't have to have executive. There are dozens of ways. Go look sometime, if you have nothing better to do, at the agreements between our antitrust people and the European Antitrust Authority. It's like that. And they're just agreements among civil servants. You see? And there are, I've quoted a few, but there are many, many ways of going about it. But I think we will go about it. And of course, I'm urging that we do participate and that there are many ways of doing it. And we should choose a few and different ones and experiment. And we'll have court cases. I mean, somebody's going to point out, I'm quite sure, in an appropriate case, which is true, that the First Amendment delegates the legislative power to Congress, not to the Southern Bluefin Oil Commission. Yeah. Okay, I'll worry about that one when we get it. But, you see, filled with legal problems, filled with a world that requires that we proceed, and certainly, I hope, under law. And that's my last point. Because I saw that again as I was driving up to Memphis. I saw a sign. And the sign, as I came up to Memphis, said, this is the place, a place, where the trail of tears, crossed. And I knew what that was. I knew what that was because the president of the Ghana Supreme Court was in my office once and said, why do people do what you say? I said, a good question. You better look into history. And the history of the Trail of Tears is that our court said that northern Georgia belonged to the Cherokee Indians. And Andrew Jackson said in a famous statement, supposedly, he said, John Marshall, the Chief Justice, made his decision, now let him enforce it. And he sent the army, but not to enforce the court's decision, but to drive out the Indians who walked the Trail of Tears, many dying on the way. And they and their descendants ended up in Oklahoma. All right? And that wasn't that long ago. And we did have a civil war. And we did have 80 years of segregation. And we've had all kinds of things. And it took a long time, and I think Little Rock was pretty important in this, when those 9 Little Rock brave children, you know, were trying to integrate, one among the first to try to integrate Central High School, and Eisenhower, who was president, talked to Brownell, and Brownell said, you've got to send troops, and he did, 1,000 troops, paratroopers, Fort Bragg, and they took the children by the hand and walked into the school. That's a big distance from the Trail of Tears. But it wasn't just the paratroopers, and it wasn't just the court. And if you look into the history of it, you will see that Arkansas closed their schools and nobody was educated, and they sent up a case to the court called Cooper versus Aaron, where they said, we don't want to integrate anymore, and the court said 9-0. No, you must. And that was 9 people. You could add 90,000. What Governor Falbus was saying, I have the troops. And I'm going to close the schools, and nobody will be educated, and Some of us remember that. But we also remember that it was a catalyst. And we began to have Martin Luther King. We began to have the Freedom Riders. And now you see what I'm saying? What I'm saying to this woman who's trying to do better in Ghana, I'm saying, don't tell the judges about how you need a rule of law. They believe that. And you needn't tell the lawyers either. What you have to do is get the judges and the lawyers and the others to explain to the people in the villages and explain to the people who are not lawyers. And by the way, contrary to public belief, of our 320 million people, 319 million are not lawyers. They're the ones that have to understand why it's in their interest to go for a decision, support it, don't fight it, even though it's important, contrary to what you want, and wrong. Try Bush v. Gore. I heard Senator Reid say that. The most important thing about that case, you see, is that never noticed. No guns, no riots in the street, No paving stones thrown. And when I talk to students at Stanford, I did, for example, I say, I know what you're thinking. 20% of you are thinking, too bad there weren't a few paving stones thrown and a few rods. I said, but before you decide that, go turn on your television set and see what happens in countries that make their decisions that way, rather than under a rule of law. You see? That's an important part of this international thing. And I'll end with one quotation, because that's just something we have to work on everywhere. And the quotation I liked to my generation was from Albert Camus. I really like it. He wrote a book called The Plague, as many of you know. And that plague was about, it was a fake. It wasn't about a plague. It was really about the Nazi occupation of France. And at the end of the book, well, he says, why did I write this book about a plague in Algeria? He says, I did it because I wanted people to know the story of what happened. He said, I did it because the hero is a doctor, and a doctor is a person who just helps other people without philosophizing, without thinking about it. He just does it. But really, he said, I did it because the germ of the plague never dies. It goes into remission. It goes into remission only one day to emerge again, to send its rats into a once happy city. That's what we're fighting with the rule of law. And that's what I hope will apply when we, as we must, begin to take into account what's going on elsewhere in the world, which does affect us. So I've only sketched out a few things that we can work on together. Thank you.
Justice Breyer, thank you very much. I want to ask you a series of questions, maybe starting with the book. And maybe you could talk a little bit about how this book fits with your other books, because you've written sort of two books about the democratic constitution and how it ought to be interpreted. And in those books, you really focus on the idea of kind of there's kind of a pragmatic streak there. I mean, you're very interested in the consequences of justices' rulings. And I'm wondering if you sort of came at this topic as another way of trying to solve problems. In other words, other countries deal with the same problems we deal with. Why not look at what their courts do? Is that sort of how you ended up?
Certainly that's true, but I think if you're talking about judicial philosophy, I think that most of us, I think you'll probably support me in this, a judge, we have some words on a piece of paper, and we have to interpret them. And in the Supreme Court, good judges below have interpreted them in opposite ways. That's why we took the case. It's a good argument, both sides. Now, we all have the same tools. We have the language. You read it. That language is important. I mean, if it says carrot, that's not a fish. Okay? And we all know it, and we're not going to say it, that it means that. You have the language. You have the history of the statute. You have tradition. Suppose it's habeas corpus. There's a huge tradition there. You have the precedent. And if the precedent solved it so beautifully, however, what's it doing in our court? But you have the precedent. You have the purpose. Some human being wrote those words, and that person was trying to reflect a purpose. He had a purpose or a value if it's the Constitution. First Amendment, about speech. Fourth Amendment, about privacy, etc. Values and consequences. So all of the judges have the same tools. We have the history, we have the language, the history, the precedent, the tradition, the consequences, and the purposes. Not any old consequence, but consequence related to the purpose. We all have those same 6 things. Some judges put more emphasis on language or history. Okay. You know, Scalia did that. We used to debate together. I mean, we'd go to a college audience. We loved it. We got on very well, and it was fine. And and some judges, like I guess I do, put more weight on purposes, context, consequences. And I would say to him, you know, George Washington didn't know about the internet. And he would say, I knew that. and then he would say, which I said earlier, he used to say, I'm not saying that looking at just the history and the language is always perfect. He said, but it's like the two campers, he would say, and one's putting on his shoes, and running shoes. He said, well, what are you doing? He says, well, there's a bear coming. He says, yeah, but you can't outrun a bear. He says, yeah, but I can outrun you. And what he was worried about with the way I approach things is it's too open. It risks the judge substituting his own values or his own desires for the law. And there are risks, but you try to avoid them. And what I'm worried about is his approach is you'd write a constitution no one wants. And who will turn out to be right? I don't know. I'm sticking to my way, all right? But do you see? So if I'm saying, look, this world is changing, I'm also saying, and our law will change to reflect it. I mean, you can't avoid it, I don't think. And the examples are meant to show that there are many areas where we just can't avoid it. And so let's look to try to get a law, decisions within the framework of ordinary interpretation that will work better.
Now, it's not every day that we have a justice of the Supreme Court here with us, so maybe we can talk a little bit about how you work and your life and what a typical day is like for a justice of the Supreme Court, since the term is just about to start. So what will you do?
Typical days. I'm reading. I have briefs with me. I'm always reading those briefs. I mean, we have two jobs. The first job is to decide what to decide. We get about 8,000 requests every year, and we hear about 80. And every week there's 150 coming in. And we have all those briefs, and there we are, law clerks. So we each have 4 law clerks, and 4 times 9 is about 30-something. And we divide them, and that's 4 or 5 for each law clerk, and they'll write memos. So I get a stack of memos like this. Now, I get those on usually Friday, and I'll read them. And it takes me a couple of hours to pick out the ones that are possible. But I've told you why that's possible. It's not because I'm a genius. I'd love you to think I was. But nonetheless, that's not it. The point is that we're looking for something. We're not looking to see. Taft said this when he was Chief Justice. William Howard Taft said, we're not looking to see if the lower courts are right or wrong. I mean, they're judges. They're good judges. Maybe they're right and we're wrong, you know. That's not the job. He said, well, what is the job? The job is to create uniformity in federal law. So if you see the lower courts splitting, which they don't do too often, but we'll probably take it. And if somebody holds a statute of Congress unconstitutional, we're almost sure to take it. And sometimes we'll take a few others. But you see what I'm looking for? I'm looking for, is there a split? Is there a special reason to take this? And so I can separate out the possibles. Then I give them back to my law clerks on the following Wednesday. We go through them, and I'm deciding whether I want it discussed in conference, the ones I've given back. And any one of us can have anything discussed in conference. Conference is Friday. We'll have usually 10 to 20 cases that somebody's wanted discussed, and we'll discuss them. And we're alone in the conference room. We go around briefly. The Chief Justice says what the issue is, and I vote to deny or grant or whatever. And people go around and they vote, grant or deny. And 4 votes to grant, it's granted. Not 4, denied. Not on the list, denied. And if I hear something I didn't expect from one of the other judges, I can say, I want it relisted till next week. And then I'll go back and look at it pretty carefully. But you see, in a sense, we can't go wrong denying a case. Do you see why? Suppose we really should have taken this case, because it's really important to the country, and what will happen? What will happen if we don't take it, which we really should have taken? The issue will come back. It'll come back in another case. So we'll get the point. And suppose it never comes back. Well, I guess the country didn't need us, did it? There we are. And I overstate, but you see the point. If we take a case we shouldn't have because there's some procedural issue in it, people have gone to an awful lot of work and they can never get there. So I look at what the papers say about the certs because I want to see not whether they think we're right or wrong, that's their opinion, but I want to see, are they talking about a cert, and I say, what case? That's what I don't want to have happen. And it doesn't. It doesn't happen. Then we hear the case. All right, then what happens? And they start writing briefs. And briefs, why are they called briefs? They're not brief. I mean, these are little booklets, and it's a blue one for the petitioner, the court was wrong below. There's a red one for the respondent, the court was right. There's a gray one if the government's always gray, if they want to file a brief. There are light green briefs for anyone, Mikey Curii who groups, or you, anyone who would like to support the petitioner, or dark green who'd like to support the respondent. And in a typical case, maybe 10, 15, 20. I'll read those. If there are 100, as there were in the affirmative action case, I have to admit, after I've read a few of the Mikey brief, I'm looking through it pretty carefully to see if there's anything new. Is there something new is not quite the same. But nonetheless, normally I'll read every brief. Not sometimes with more care than others. Then my law clerk will, they divide those 12 into, we hear them and we get groups of 12. And the law clerk, that's 3 for each law clerk, and they will read them more carefully, but more importantly, they will write what I want them to do research on. And then they will put in the other things too. And I'll read the briefs, I'll have a discussion. Monday, we're having our first case for the October session. The October session is 2 weeks long, 3 days each week, 2 cases each day, normally 12 cases in a 2-week session. First 2 weeks of October, November, December, January, last 2 weeks, February, March, April. All right, the October session, those 12, I've read the briefs. I have a memo. I've discussed it with my law clerks. Then we have oral argument. And oral argument is for us to ask questions. Lawyer gets up and says something new. Why didn't he put it in the brief? And we think we know those briefs. We think so. I think we do fairly well. But we ask questions. And it is a nightmare being a lawyer in our court. You see one judge sort of going, and the other going, and there we are. And then after that, 2 days later, we're in that conference room. And we'll discuss the cases we just heard. And the Chief Justice, we're by ourselves. We each have a book referring for the case, for each case, and it has space to write down what the others think. And the Chief Justice will say the issue is thus and so, and this is what I think, 5 or 10 minutes. And you can get a lot covered if you try to be succinct, and that's what you should be. And we do. And then it goes to Justice Thomas and Justice Ginsburg and me and Justices Alito and Sotomayor, Kagan, Gorsuch, and Kavanaugh. No one speaks twice till everybody speaks once. Very good rule for any small group. And particularly for me, who was junior justice for 11 years, all right? But nonetheless, good rule. Then you go back and forth. And it works best if you're paying attention to what the other person said. Not, I have a better argument than you. Because if that's what you're saying, the other person is going to think, no, I have a better argument than you. But if you listen, sometimes you get somewhere. And then at the end of the conference, we know how it's broken out. People have said how they're thinking of voting. It's tentative, but it's pretty not tentative. It's fairly definite. And the Chief Justice, at the end of the 2 weeks, will assign, if he's in the majority, whoever's senior, he'll assign the opinion to be written. But he's more constrained than people think, because he has to, everybody gets 1 to write, and a majority, before anyone gets 2. And then 2 before 3. And moreover, etc. And moreover, he has to assign it in a way that will produce 5 votes if it's divided. Half our cases are unanimous. 5-4 is probably 20%, 15, 20%. Last year, the two most recent appointees, Gorsuch and Kavanaugh, were on the cases that weren't unanimous. They were together and apart an equal amount. And on the 5-4s, I just looked this up, I saw it. On the 5-4s, there were 19, that's a lot actually, out of the 70 or so, that were 5-4, and you say the usual suspects, according to this papers. They were together, it was the usual suspects, in 7 of the 19. And it was not the usual suspects in 12 of the 19. So why did they say in an unusual? I mean, you say, there we are. But in any case, if I'm writing the opinion, what I do is I will go to my law clerks and I'll say I want a draft or a long memo, and then I'll take that memo, usually 2 or 3 weeks later, and I will go home with the briefs that I want, and I sit down at the word processor and I write my draft. I give it back to him. She thinks, by the way, hers was better. But nonetheless, there we are, and she'll write another draft, and I'll write another draft. Usually it's 2 from scratch, and eventually we get something we like, we circulate it, and I hope I pick up 5 judges at least. I'd like 9, but I'll settle for 5. And then people can write dissents, or they can write what they want, and eventually everybody's written, or everybody has joined an opinion that somebody else has written, and it comes out. And now you understand how the court works. And what I said to my son when he was in high school, and we were talking about this, I said, that's what I do. I read and I write. And if you do your homework well, you will get a job where you can do homework the whole rest of your life.
Could you say a little bit more about that interaction among the justices? There was an interesting piece in, I guess, the Wall Street Journal yesterday about justices during oral arguments passing notes up and down the bench, and
there were notes at the top with jokes and so forth. I mean, that's like some professor somewhere has decided to make a career out of looking to who's the funniest justice. You know, that's like being the tallest short person or something. I mean, fine, if they want to do that, fine, that's up to them. But it doesn't have much to do with anything. I get on very well, Justice Thomas and I do. We have a very good relationship, and we're friends, and sometimes something will strike us funny, and I might send him a note saying, he'll laugh because I'm going to send you one. And what we do after it, as I said to the reporter who was writing this, is burn them. Right. I don't want them to appear somewhere. I mean, there is nothing wrong with them, but I just assume people focus on other things. But we get on well. I've never heard a voice, to this moment, I've never heard a voice raised in anger in that conference. I have never heard one judge in that conference room say anything snide or even funny at someone else's expense or insulting to other people. It is very professional. We are professionals. And we go around and discuss the cases and discuss them back and forth. And that's generally true of judges. The inside story of a court is usually that there is no inside story, or at least very little. Why? Because the job is to write an opinion, and the opinion is supposed to, if it's a good opinion, give the true reasons that the judge believes that the result is so-and-so. That's very different from Congress. Congress doesn't have that job. Congress's job is to enact the law. Now, the law does not say why it itself has been enacted. So obviously there are going to be interesting inside stories as to why that law was enacted. But that's not true of a court. I'm not saying zero. I'm not saying there's zero inside story. But of course, usually when you get down to what's going on inside, it's not that different than what you thought from reading the opinions and so forth. So there's minimal inside story.
Mm-hmm. And in the setting of the conference, as you all are sitting around and you're talking about all of the issues, how hard are you working to try to convince your fellow justices? In other words, how does that process?
It depends on the case, to be honest. I mean, with you, You listen and see where they're coming from. Look, everybody knows among the 9 of us that all 9 would always like all 9 to agree with him or her. Right? We all know that. And so if you want someone to see things from your point of view, and sometimes I will go in and talk to some of the judges, I might talk to someone or other, but I better be interested in what they say. And I better be thinking I'm not sure about this point. And I better really think it, because there's nothing that happens so quickly as people know when you're being phony. And it has to be an honest conversation. And those conversations do sometimes occur, and sometimes they change people's minds. Completely rare, but sometimes, and often about how to look at this thing. And how to look at it is important in court, because it depends how you look at it, what the words then end up being. And those words are what control the lower courts, the lawyers, the clients, the average person who has to live within the interpretation that we are making of the statute or of the constitutional provision. And so there is some conversation, not enormous, but some.
So you've emphasized the time that the justices, or the extent to which the justices might be unanimous or in agreement with each other. But we know that we live in a very polarized sort of time, and with media and the 24/7 news cycle and social media and everything else. To what extent has that exaggerated these 5-4 decisions and therefore hurt the public reputation or the image of the court?
Yeah, I think that's our greatest problem. You go back 40 or 50 years, the newspaper stories didn't say every story who appointed this judge, was he a Republican or a Democrat. That was good for the judiciary, and that was good for confidence in the judiciary. But that isn't the world that we live in. And I think most people who aren't following it too closely think we're always divided about everything. Well, we're not. But what do? How do we do it? Well, here I am, A few people are listening, and I will, when I have the chance, tell people how it works. And so will my colleagues. I believe that on law day, the lawyers ought to go out and talk to the newspaper people, and talk to the high schools, and talk to the to those who will listen, and say, look, this is your law, I mean, it's not us. It's your law. We're interpreting it. It's your institution. And when I talk to the high schools or the colleges, I'll say, look, I hope, I can't tell you how to lead your life. I hope you, in your life, I hope that you find someone to love. I hope that you have a career that's rewarding. And I hope that you participate to some degree in public life. And I can't tell you much, but I do work with this document. And I do know that if you don't, this document, the Constitution, won't work. And I'm pretty sure of that. Because I want them to participate. Because I want them to see. That's why we built this courthouse in Boston the way we did. We want people to think this is a public building. It belongs to the public. It's yours. Hey, I'm not there to tell you what to do. Maybe you put me there. But this is you. This is yours. That's great. I'll get, I think that's the great thing about this country. We have 320 million people, and they all think something different, but my God, somehow they've decided to live together, and they live together under this document that, to a considerable degree, imperfect, but it provides a democratic system of having a democracy and basic human rights and a rule of law. Those 320 million, there they are. My mother used to say that. She used to say there's no idea so peculiar there isn't somebody who doesn't hold it in this country. We were in San Francisco. She said they all live in Los Angeles, but nonetheless. You see the point. You see the point. Okay, so what I think is the most important thing? Somebody asked me that the other day. I think the best thing I've ever done is that courthouse. And I didn't design it, but I helped 3 days a week. For 3 years, probably half a day a week, with another judge and with our great architect, Harry Cobb. And the idea is, make people feel it's theirs. Make people feel they can use it, not just for court things. Make people feel that this means something, this judicial thing. And I think it worked pretty well. And that will last. That will last. You see why? And the newspapers help with saying, oh, they all fight all the time. No, they don't.
Right.
I guess they should say it if it were true, but we don't fight all the time. I can't say zero, but I can say it's more just doing your work and it's quite often agreeing much more than people think.
So when you hear talk of placing term limits on the justices or expanding the size of the Supreme Court, how do you respond to that, or how do you react to that?
I don't react. I am not going to get into some kind of political discussion, at least not now.
Fair enough. What about education, specifically legal education? So your book outlines the world as a complex place. There are all of these problems. Is there something that needs to be changed about legal education when it sort of comes to the sort of way that we teach lawyers? Does it need to be changed in some way to reflect some of the realities that you're talking about? Are there disciplines? Are there fields?
I don't know. I'm not going to know that I did teach many years ago, but I haven't been, since I've been on the Supreme Court, I haven't really taught. It seems to be working pretty well as far as I know. The only thing that you read about, of course, I don't know how accurate it is on campuses where people seem, in some instances, not to understand that the First Amendment is there and free speech is there for people you don't like. Hey, there's no need for a First Amendment or freedom of speech if the person is going to say something that you think is great. Or even if you think it's passable. It's there for people who really say things that are just terrible. And from what I read, I'm in working with a First Amendment, and so I work with it. It's part of my job. And you say, God, is it really for that? I said, yeah, really is. Don't get into this business of starting to say which is good and which is bad in terms of being allowable. You can say it's terrible. Say it. It's terrible. But don't stop him from speaking. And that's what I work with. And I've come to believe that that's a pretty important principle. So I'd like to see that a little bit more sometimes.
Mm-hmm. And also thinking about education, undergraduate education, you have spoken, for example, I know at the Folger Shakespeare Library and the University of Chicago. You've talked about law and literature, for example. How is it, or how does reading literature, or how does a liberal education affect how you think as a justice?
Yeah, I think that, it's just personal, but I'll get a question. What should I study as an undergraduate if I'm going into law? I say, you're very lucky. Law is a graduate institution. Don't study something related to law. I say, here you are for 4 years. You realize that? That's fabulous. And you don't have to study something related to law. You'll learn about computer science. I don't, you will, okay. And you'll learn about science, that's good. But try liberal arts. Try learning a foreign language. Try reading a few novels. Say, why? Why? Well, I think why, one reason why, is because you only have one life. Each of us has one life. And we know pretty well our own life. We know it pretty thoroughly. And we know our families. We have a few friends. And we know something about them. But there are billions of people in the world. And the best way to find out about lives that aren't yours is by learning French or learning Spanish or learning Chinese or something, and you'll see it's a different culture, and you will be different, and you'll learn something about how other people live. And the same is true of literature. It's our best way, I think, into the minds of others. And that means it's the best way to produce a kind of understanding. So I love it when people are taking liberal arts.
The year 2020, as you probably know, will be the 100th anniversary of the ratification of the 19th Amendment to the Constitution. And the student wonders whether you see any potential major advances for women's rights in the United States in the foreseeable future.
Yes, but that isn't necessarily us. It might be, or it might not be. I'll tell you what, to see what you won't think of. I heard a colloquium on the 19th Amendment. I mean, it came a little late in the day, you know, but it did come. And it has had a lot of influence, maybe not directly, but at least indirectly, in other amendments to the Constitution, in other parts of the law, etc. And so, liberal arts college, I throw movies in too. And you know, some of my favorite movies were really influenced, I learned, because don't tell me about this. My last year of law school, we were allowed to take one course in the college. So I said, I'm taking Stanley Cavell's course on movies. The dean called me and he said, you're taking a course on the movies? I said, you said we could take a course, and so we couldn't get out of that. But Cavell's point, which was pretty interesting to me, is if you look at a lot of the divorce comedies in the 1930s, you know, Philadelphia Story, The Awful Truth, His Girl Friday, great movies, I really recommend them. And what they're about is these are the children of the suffragettes. See, the children of the suffragettes. And they've seen the 19th Amendment pass. And now they say, we're going to try to face, at least in these films, at least in art, we're going to trace a different problem. It's called having a mature relationship with a man or a husband. That's what those movies are about. You see, and I put Groundhog Day in there. Why do I put Groundhog Day in there? I put Groundhog Day in there because I put Shakespeare in there. I mean, Shakespeare, try as you like it. I mean, my goodness, what Rosalind falls in love with a wrestler. Rosalind is a very intelligent woman, and she's in love with this man, and he doesn't quite know how to behave. And so he says the same thing she says to her friend that they say in Groundhog Day. The woman says to the man, you're going to keep doing this till you get it right. And that's what the divorce comedies do. An immature relation, we have a divorce, and then there is a coming back together in a more mature relationship. Now that's a tough problem. That's a tough problem. Go read Euripides, you'll see it existed there. And you'll see that it's existed throughout history. And do I believe progress will be made there? Yes, I do. I do think it's possible. I do. It's optimistic, hopeful, and I think it'll happen. It's happening.
A survey that was done by the Annenberg Public Policy Center at the University of Pennsylvania on Constitution Day 2017 found that only 26% of Americans could actually name all three branches of our government. And other surveys have put this number a little bit higher, into the mid-30s, and I think you have even joked that more people can name the Three Stooges than the three branches of the U.S. government.
That's a very sad joke.
So what do we do about that? How do we change that?
Well, Sandra O'Connor was the one who was working on that, and Tony, and we do what we can. We try to get civics taught again in the high schools. There are high schools that don't teach it. My goodness, I find that a surprise. Of course, you shouldn't graduate from high school without knowing how government works. And you shouldn't graduate. You know, I can say that till I'm blue in the face. But what I'd really like to see is the Secretary of Education, under whatever presidency, get together with the Attorney General under whatever presidency, and set up a few civil servants who have it as their job trying to figure out how to go around the country to talk to the legislators to be sure that it is required that you do learn how our government works in the high school. I think that's possible, and I don't think it's very partisan. I think it is absolutely nonpartisan and should be done. That's the most I can say, but it's important.
Justice Breyer, you've been very generous with your time here tonight. Thank you very much.
Thank you.